Superintending Fields Al-Waheed and Serdar Mohammed of the Ministry of Defence.
Lord Sumption will explain the judgment of the court.
The capture and detention of enemy combatants has been a feature of the conduct of war throughout its recorded history. This appeal is about the right of British forces operating under a mandate of the United Nations Security Council in Iraq and Afghanistan to take and hold prisoners in the course of military operations there. The issue arises because in Afghanistan and at the relevant times in Iraq, the hostilities were not between belligerent states. They were what is called in the literature non-international armed conflicts, i.e. armed conflicts between peacekeeping forces and governments on the one hand, and organized groups rebelling against those governments on the other. The claimants contend that under Article 5 of the European Human Rights Convention, British peacekeeping forces operating in support of the governments of Iraq and Afghanistan have no power to take or detain prisoners except for the purpose of handing them over promptly to the relevant governmental authorities for criminal investigation or prosecution. The claimants also say that even if there was a power to detain them in principle, the procedures applied by the army did not comply with the convention because there was no effective way in which the propriety of their detention could be challenged. These contentions have been broadly accepted by both the assigned judge, Mr. Justice Leggatt, and the Court of Appeal, although for somewhat different reasons. The legal implications of their decisions are very significant, because soldiers engaged in overseas operations and doing things inseparable from the conduct of armed conflict will frequently be immune from liability because of the doctrine of Crown Act of State, which Lady Hale has just summarized. But it is common ground that there is no such immunity for acts which violate the Human Rights Convention. The practical implications for the conduct of future peacekeeping operations by British forces are obvious. The Supreme Court partially overrules the courts below. Their decision can be summed up in 5 points, on each of which the court has arrived at its conclusion by a majority. First, in common with the Court of Appeal, the Supreme Court concludes that subject to any relevant restrictions imposed by the European Human Rights Convention, a power to capture and detain enemy combatants was implicitly conferred by the relevant Security Council resolutions in any case where this was necessary for imperative reasons of security, that is to say, for the security of the armed forces themselves or the civilian population. The resolutions authorized the taking of all necessary measures to protect the civil populations and the reconstruction of the Iraqi and Afghan states, a well-understood phrase which encompasses military action. By definition, those measures include the capture and detention of enemy combatants for imperative reasons of security. Secondly, the Supreme Court rejects the conclusion of the judge and the Court of Appeal that this power was limited in Afghanistan to the 96-hour period allowed by the procedures of the liaison organization for the international peacekeeping forces there, the International Security Assistance Force. The United Kingdom was entitled to operate its own detention policy, and the power of detention was in principle exercisable for as long as the imperative reasons of security continued to apply. Thirdly, and critically, this court decides that capture and detention of enemy combatants is not inconsistent with Article 5.1 of the Human Rights Convention. Article 5.1 specifies 6 cases in which detention is permitted. The 6 cases were primarily designed for peacetime conditions and are not easily adapted to armed conflicts in places where the ordinary processes of the criminal law have partly or wholly failed. They did not apply in these cases. They cannot be regarded as exhaustive, however, as applied to detention in the course of military operations in a war zone. This is so whether the armed conflict in question is international or non-international in nature. In both categories, the capture and detention of hostile forces is a necessary feature of the conduct of lawful military operations. Fourth, the Supreme Court decides that the desire to interrogate Serdar Mohammed was not a legitimate reason for detaining him, either under the Security Council resolutions or under Article 5 of the Human Rights Convention. There was a period of some 3.5 weeks when he was retained in custody for interrogation purposes, but there is an issue, which will have to be tried in due course, about whether his detention in that period was also justified as being necessary for imperative reasons of security. He may be entitled to damages so far as the total duration of his detention, including any period of imprisonment pursuant to the sentence of the Afghan courts, has been increased by the process of interrogation. Fifth, and lastly, the Supreme Court decides that the Army failed to comply with the procedural requirements of Article 5 of the Convention. These, in summary, require that any detention should be authorized by law and that the detainee should have a reasonable opportunity to challenge it. We have no doubt that this was authorized by law. Clearly, however, there must be some adaptation of the procedural provisions of Article 5 to accommodate conditions in a war zone. This court, however, considers that even so, the arrangements in Afghanistan for the review of detentions by the British military command there were inadequate. This is because the only reviews of the decision to detain a prisoner were conducted by the same senior officer who had authorized it in the first place, and because there was no provision for participation in the reviews by the detainee. They cannot therefore be described as affording him an effective right of challenge. It is right to add that the majority are agreed that the procedural defects of the system do not mean that Serdar Mohammed will necessarily be entitled to damages. This is because even a compliant review process would have been unlikely on the facts that we are assuming on these appeals to have resulted in his release. For these reasons, the present appeal will be allowed in part and appropriate declarations will be made. The case must then go back to the High Court for the trial of the remaining issues in the light of our conclusions.